Hello and welcome to Change India, experiments with big ideas. Today in the final show of our four-part series, let's look at a simple but powerful idea to decriminalize our political system. In the 15th Lok Sabha, which completes its term next week, 162 MPs out of 543 or 30% of all Lok Sabha MPs had criminal charges against them. 72 MPs faced grave criminal charges like murder and rape. This simply must be reformed for the health of our democracy. So how can we implement this big idea? We propose a fast-track 12-month special judicial system. 1. Set up 2 dedicated fast-track courts in each state to hear cases against MPs, MLAs and those who filed nomination to contest the last general election and assembly election in that order of priority. The hearings should be carried out on a day-to-day basis and a judgment should be made within 6 months. A person found guilty would have the right to appeal to a high court, but the high court must admit and dispose the appeal within 2 months rather than hear a plea for admission of appeal, which is currently the case. A person found guilty can then appeal to the Supreme Court. Like the High Court, the Supreme Court must hear and dispose the appeal within 2 months. Remember, there are only 5,364 elected MPs and MLAs in the country, so the numbers can be handled. To debate this idea, we have on a satellite link from Bangalore, Justice N. Santosh Hegde, a former Supreme Court judge and an activist for clean politics. And in the studio, we have Dr. Kiran Bedi, a former Indian Police Service officer who has also been a crusader against corruption. With him, of course, is Dheeraj Nair, CEO of Network 18's Think India Foundation. Justice Hegde, you know, on paper, this sounds effective and doable, but you've been through the judicial system. Is it going to clog things up, or is this something that can actually be done?
No, it can be done, provided they have the will to do that. As a matter of fact, I would suggest an amendment to what you suggested. There should be a trial court. We should dispose of the case within 6 months, and there should be only one appeal, not more than that, appeal to the High Court, and that should be final. There is no point in having a second appeal to the Supreme Court. This is a major problem in our country. We have too many appellate and revisional courts. We got to reduce that number of appeal and revisional courts, confine it to one appeal only, no revisions should be allowed. And the mandate to the court should be, trial court should be within 6 months they should dispose it out. Now I would like to say one thing here. The recent judgment of the Supreme Court has already given that direction to all the subordinate courts. They have said any elected representative's case should be tried immediately and not beyond 1 year, they have said. But I think your suggestion for 6 months is good enough and all. And they have also said if it can't be tried and completed within 1 year, they should report it to the Supreme Court. It's a good step taken by the Supreme Court, but I think even the time period should be reduced to 6 months in the trial court and 2 months in the appellate court.
So quickly, two points from what you've said. One, if you don't allow a final appeal in the Supreme Court, will it then be seen as going against the principles of natural justice, because these are obviously going to be elected representatives?
In most of the democratic countries abroad, only one appeal is allowed.
Right.
Take for United States. The Supreme Court of the United States doesn't entertain these appeal matters, except it's a constitutional matter. Like that, we have got fixed to an idea of giving absolute justice by filtering it through various appellate forums and revisional forums. This is a major hurdle. Take some of the major cases. Take Lalu Yadav's case. In between the trial, they have gone any number of times to the High Court and the Supreme Court,
right,
and the trial was stuck there. This should be prevented first.
Right. Dr. Bedi, Justice Hegde seems to suggest that if we really put our nose to the wheel, then this can happen. I also want you to think a little bit about, that's the judicial system. There also has to be an investigative process. Are our police forces at the district level, at the state level, set up to handle this, or will you need a special investigating team doing just these cases?
Maybe it will have a capacity varying from state to state. Maharashtra may be better off, Delhi may be better off. Well, developed states.
Right.
There's a problem of developing police and developed police. Right. Developed states and developing. I think you'll have a state-wise difference. But if there is a hammer like this, if there's a direction like this, I can tell you the police DGPs will find the way, or they will work towards it. But I think we need to begin with it straight away and begin with whatever resources we have. They would be capable. I think the only delay would be forensics evidence,
right,
where you may need forensics, which is delayed. So I think the forensics must also pitch in, and so should the police, and begin with whatever we have, but then move. But remember, a fast track investigation and trial will reduce crime in the end.
Right.
So it will have a positive effect later.
Yes, absolutely. Now I want to come to the demonstration impact of that, but I still want to labor one point, and this is, you know, we have grown up in this whole system of tariq pe tariq. You keep on getting dates from the courts. Now, can a fiat ensure that that is not done? That lawyers turn up, the judge also says, okay, maybe one more tariq and then that's it. Can it be done?
It depends on the presiding officer. I've seen certain magistrates doing it. Didn't they do it in Nirbhay's case?
Right.
So if Nirbhay's case can be done, why not in others?
Right.
They've done this in that Shakti Mills case.
Right.
If that court can do it, why not others?
Right.
And there have been many rape cases in Rajasthan. They've had a conviction within a month. If that could be done, where the prosecutor, the judge are on the alignment. But I must tell you, where we need the cooperation is bar councils. We must co-opt them in this decision.
Right.
Because where the problem comes is adjournments from the defense councils.
Right.
For very flimsy things.
Right.
So I think if you have the bar council on the same page,
Right.
it will make a lot of difference.
Okay, let me quickly get Justice Hegde's thought there on how to get over this tariq pe tariq syndrome. As Dr. Bedi spoken about, the bar council needs to really come in and be a part of this initiative.
Well, I think we can't put an embargo on the presiding officer giving dates depending upon the circumstances under which it is sought for. But I think every time a case is adjourned, that matter should be reported to the higher authorities and under what circumstances the adjournment is given.
Right.
People who do not give adjournment easily, they should be, presiding officers should be encouraged by the superior courts.
Right.
That will certainly make a difference.
Right. So, Dheeraj, you've heard. This is a question of the will being applied, a lot of demonstration, a lot of leadership by example.
Absolutely, and in a way, it's a sad reflection on our judicial system that we're talking about fast-track courts at all. Because after all, in a democracy where there's supposed to be justice for everybody, every court, every trial should be fast-tracked. I mean, there's no reason why trials in other parts of the world, we've seen trials start to finish in 6 months, complex trials, financial cases, I mean, not even regular cases of murder and rape. So there's absolutely no reason why this can't be done. But as a special exception, since we are talking about the apex of the political system, I mean, lawmakers, we really don't want any criminals and sort of people making laws who've broken laws. I mean, that's absolutely absurd. So for them, a special dispensation, as you said in your introduction, the numbers are manageable. There's about 5,000 people we are dealing with. And we can deal with them. And then, as Dr. Bedi said, after that you start a virtuous cycle. It'll deter criminals from getting into politics because they know they can be convicted and disqualified. So there'll be a deterrent effect and better people will come in. So that's one way. This fast track is one way to start reforming the system. I'm not saying everything will be solved, but we can make a good start and create a virtuous cycle.
Okay, so we have talked about a virtuous cycle. I'll take a break at this stage, but when I come back, I want to talk about how this virtuous cycle will play out, because while there are 5,364 actual elected MPs and MLAs, the number of candidates who make an attempt is much larger because there may be 10 or 20 such candidates per constituency. Also the fact that you've got a situation where there could be some unintended consequences of this. So stay right there and come back after this very short break. Welcome back to Change India, experiments with big ideas, and today we are looking at a rather simple but powerful idea, which is that all elected representatives, to begin with at MPs and MLAs level, which is in number about 5,364, if they have charges against them, all of those should go through a fast-track court. We've also had a suggestion on the show which says only one appeal up to the High Court should be permitted. The High Court should be asked to dispose that appeal off in 2 months. So between the trial court and the High Court, the whole process can be handled in about a year. Justice Hegde, one nagging doubt, and this is perhaps an unintended consequence. Now, if this was to actually become effective at the MP-MLA level, then what could happen is that a lot of the criminal element would fight shy of going to that legislative level, may then try and crowd the lower levels of administration, the Zilla Parishads, the Panchayats. Now that is where the people are even more exploitable in a sense. So could there be an unintended consequence of pushing the criminal element down the chain where they could bunch up?
It is possible. It is possible that they may go to that arena where the fast track courts do not come into picture. But then that should not deter us from proceeding with this idea, because somewhere we must start this, and then alone ideas will come up, and maybe this can be expanded to other elected bodies also later. But for the present, I think something should be done from the top.
Right.
And there's a more important thing other than law also. I think we got to change the attitude of the society in regard to this. Today the society thinks everybody is corrupt, so what if it's corrupt? That is the attitude that is prevailing. No, I think we got to educate the people on that. That let there be corruption, we'll fight corruption in a different level, but corruption in politics is something that cannot be tolerated. Those people sitting, lawmakers cannot make law when there is a allegation of corruption against them, or again could be any criminal other charges against them.
Right.
Therefore, simultaneously we got to change the attitude of the society with the change in law. Let us start from the top level. Let it go to the panchayat level, the Zilla Parishad level later. Let's try this out.
Right. Dr. Bedi, this whole thing of unintended consequences, we've seen it, for instance, and I don't want to become too pessimistic here, but I just want to debate this point through. We've seen this, for instance, in the anti-defection law, where it was started with a particular noble purpose, but actually ended up achieving perhaps just the other exact opposite, where it ended up actually making MPs and MLAs mute. Could this, for instance, ensure or at least push the criminal element down to the lower level?
I believe the kind of awakening of voter awareness which has got generated in this election, I think they'll get voted out. They'll get booted out. They'll get voted out because they're closer to the people.
Right.
While the MLA and the MP is a little distant away, and the larger constituency, this is a smaller constituency.
Right.
So everybody will know you're the criminal.
Right.
Isne ye kiya.
Right.
So they'll get voted out, booted out, booted out.
Right.
So I think it will have a very good cascading, very positive effect. They will be shy of fighting a local election because of criminal record.
Right. So, Dheeraj, you think that demonstration impact is going to work?
I think it will work, and I frankly think there should be some support for this among political parties, because right now they have to hide behind this winnability factor, it doesn't matter, the charges have not been proved, and so on. I think that will end. And frankly, I think the top leaderships of parties, at least for hardened crimes, whether it's murder or rape, I don't think anyone particularly fancies having such elements in the ranks of your party in parliament. So there may be, you just need something, a catalyst to, get this lot of people out at the start, and then maybe there'll be the demonstration effect will take over. But I don't think it'll work without that first round of people being disqualified, convicted and disqualified.
Right, and you also don't see too much danger of it going
well,
down.
There's always the danger that a criminal may put up his wife who's not a criminal. I mean, we've seen that before.
Yes.
Somebody charged puts up his wife, nephew. Right? There's always that risk, but shouldn't be a reason not to do this.
Yeah, but the chances of weeding out would be higher also equally. Grassroots, because many panchayats people are independent, they're non-political.
Right.
So how would a criminal get it? Unless it's a totally criminal constituency, which criminals, I think that was...
But those are exceptions, in the bulk of the... Justice Secretary, how will this now get done? Will the government have to bring a new law? Will it have to bring a new proposal? How will it ensure that a law passed in Parliament will actually then cascade down to different legislative assemblies? Give us the mechanism of how this can be done.
Well, it could be done by the parliamentary enactment, by amending the Criminal Procedure Code, reducing the number of appeals and restricting the number of revision petitions. As a matter of fact, in criminal proceedings, revision should be done away with and all. But it may not take much time, because there is already a direction of the Supreme Court which will be the law of the land until it is altered or supported otherwise by a legislative act by the Parliament. And whatever the Parliament does will be applicable to all the states. Therefore, if Parliament makes up a mind and reduces the appeal provision to only one appeal, and also the adjournments to be controlled by the judicial officer presiding over the matter, I think it will work. A few amendments to the Criminal Procedure Code may also be necessary. That also may not be of much difficulty if the Parliament could pass that.
Right. Dr. Bedi, once again, this whole point about if only one appeal is permitted. Now, we have a system where we've gotten so used to cascading it up and up and up. I'm troubled by that thought of principles of natural justice. Somebody will go, and then this whole process could get into division benches and single benches and all kinds of legal rigmarole.
As long as that person who's convicted is not sitting MLA and MP anymore, let him go on going on appeal. I don't think we should wait for that. Because the key thing is he has been unseated.
Right.
unseated. He cannot
Right.
continue to debate and
Right.
vote. He's not a member of the MLA
Right.
assembly. Therefore, I think the purpose of the judgment of Supreme Court of 10th of July is served.
Right.
Whether Parliament enacts a law quickly or not, you already have the law of the land.
Right.
I think all we now need is a whole new mindset of the presiding officers. That means judicial training, messages by the Supreme Court, High Court, registrars should be very clear.
Right.
We are firm on this law.
Right.
So even if you still give him the right to appeal to the Supreme Court, nothing lost as long as the person is unseated.
Now, who should be doing the investigation? Should it be the Lokpal Lokayukt structure, or should it be the normal police force?
No,
of the state?
normal police force. After all, Nirbhay's case was done by Delhi police. Shakti Mills has been done by Maharashtra police. All police are capable of doing it.
Right.
I think all we need is the will and very clear understanding that this has to be finished within. First of all, investigation must finish. Otherwise, the investigation.
That was my fear. Yes.
That's the fear. But I think once these directions of Supreme Court are clearly understood, the Director General, and they could fall foul.
Right.
If they violate it,
Right.
I think it will make the change.
Right. Dheeraj, there is a little counterpoint of view that if the police apparatus of a state may be a little bit shy of acting tough against a politician who could be a minister, while the Lokayukt structure or the Lokpal structure is a little bit more independent.
Well, I mean, there's always that argument which can be made. But I think in India, we've just created this system where the police is scared of a minister. I think that mindset can change very quickly if the supporting institutions are there. So, I mean, if the police is guaranteed protection by a superior authority, especially the Supreme Court, or if Parliament enacts a law to this effect, then the police officer will feel emboldened to act in accordance with the law.
Right.
And there's no reason to fear authority. And if all this is coupled with a broader administrative reforms agenda, a broader police reforms agenda, then it will be all the more powerful. It will empower the police, it will empower the judiciary, it will clean the system.
Yeah. Justice Hegde, your thoughts on whether it should be the normal police apparatus which should be handling investigation, or the Lokayukt, Lokpal structure which has more constitutional autonomy from the state administration?
Let me clear one thing in the beginning itself. The principles of natural justice is not a matter of a fundamental right. It is controlled by a statute. Therefore, let's not bother much about principles of natural justice. Coming to the police force, I worked as Lokayukta Karnataka for 5 years, and I had a police force called the Lokayukta Police, headed by an additional Director General of Police, and they worked tremendously well, and they proved to the people of Karnataka that they can handle anybody, however high he might be. I'm sure you all know how many people they have investigated and charge sheets have been filed. Therefore, the existing police force, if it is properly handled, will certainly deliver the goods.
There you are. There seems to be a clear consensus here that while this may be difficult to achieve in the first few rounds, if it is implemented with the right political will, with the right messaging, it can be done. And then something like this will have a huge downstream demonstration impact, and the virtuous cycle will start. Therefore, it's a simple idea, but it's a powerful idea, and it's a much needed thing to decriminalize our political system. Thank you very much.